we have a large gap to cover actually, so we have to talk a little bit about the act, refreshing the memory, at the same time talk about the new rules which have come out, which is more topical, and what you should be worried about, what could still change possibly till 18th of February. The consultations are open, where you can give your inputs and see that these changes are brought about. So with that, we'll straight away get started. Maybe Tanu, we can move to the first slide of the deck. Right. So you were aware that this has been a long journey, right? From July, August 2017, the drafting process started, and then we had, finally in August 2000, the version change. Of course, Justice Sri Krishna prepared a version, and then the government scrapped that, and thereafter a leaner version of the draft, came into place, which finally went ahead in August 2023 to become the present day DPDP Act. Towards the end in 2023, it moved fairly fast. You'd all remember that, it crossed the Lok Sabha on 7th of August and Rajya Sabha on 9th of August, and finally it received presidential assent and was published in the official gazette. Thereafter, there has been a bit of a long wait for the draft rules to come out. And we'll talk about the journey from here onwards, how much time could be taken, what is the next steps, etc. So you can move to the next slide. Sorry, Shubhajit, I think you can just please go on mute. Yeah, we can. Yeah. So what are the top 8 things, therefore, you should know about this particular piece of legislation? One is that it applies to digital personal data only. Next is that there is no specific obligation on data processors. With everything that has been written in this document, in this act, is all about data fiduciaries or data controllers. Now, what are these? Very sort of crisply talking about it, it's any entity which is determining the purpose and means of what has to be done with the personal data is the data fiduciary. In global parlance, this entity is called data controller. So the entire obligation is on data controller, and nothing is written, no obligation per se on data processor. So let me give you a simple example to make this easier for everyone. Suppose in your organization you hire a payroll service provider, right, to whom you say that first of every month these 1,000 employees of ours should get these respective salaries, and you give the entire employee data to them. So what happens in this context is this company is actually determining the purpose and means of what has to be done with the personal data. Okay. And the service provider, which is the payroll service provider here, is just following the dictat. So they are data processors. So what you have to do in this context is ensure, if you are a data fiduciary, to pass on all the relevant obligations to the data processor. This is increasingly becoming difficult. This contractual relationship is increasingly becoming important because in one of the recent data breach instances, the sector regulator asked the player which had suffered the incident because of a contractual relationship that they had with a startup to provide KYC services. The questions were like this. Question number one, do you have a contract with this counterparty? Please provide us the contract. Question number two, was there any data privacy protection related provision in that particular contract? If yes, please highlight and separately provide. Question number three, did you check that this party had only written it down or could stand behind whatever data privacy protection provisions are written there? Question number four, did you ever ask them to delete any data? If yes, please provide evidence. So you can see it's not like mythical. It's not like we'll see after 2 years when this law comes into play, etc. All that kind of thought process, I think we should do away with because this is happening as of today. Okay. The regulators are asking these questions. So moving on, I think the next point here is, no, sorry, just beyond the slide, I was just on the next point. So transfer of this personal data to other jurisdictions. When we started drafting this law, I think we started from a position where we talked about almost hard localization. Then there was a slippage and they said, okay, we'll do partial data mirroring, and some kind of partial data localization. Localization, as you know, is our data should remain in our country. There are several theories and counter theories for this. One is the trade theory, that it is my data is my oil, and therefore it should remain in my country. The other theory, of course, is the security theory, that my people's data should be safe, and it should therefore remain in my country, etc. The present DPDP Act gave a clear leeway, and it said that data can be transferred and transacted to any jurisdiction, no problem. Okay. Only problem, there was only two catches. One is that if there's a stricter law, then that will still prevail over this general leeway. And the second one was that there will be short negative list of jurisdictions. Transacting in data qua those jurisdictions would be embargoed, or there could be certain restrictions. Now, this has also evolved a little bit in the draft rules. We'll talk about it, but that's what it is as far as the DPDP Act is concerned. Next point, no categorization of personal data into sensitive personal data, critical personal data, etc. Also, no non-personal data coverage. Okay. Next is, if you're handling children's personal data, you have to be additionally careful, because there are a lot of enhanced requirements pertaining to that. Firstly, of course, the age of child is 18 years. You cannot do targeted advertisement or tracking or monitoring of children. And if you're handling children's personal data, then you'll have to have verifiable parental consent. We'll talk more about this as we go ahead. Next point is on data breach reporting. Interestingly, very different from different other jurisdictions, there is no materiality or risk-based threshold which is there. It's like a wide definition, and to report everything to the data protection board and also to the individuals. And finally, huge monetary penalty. You would have read about it, 250 crore or more, depending on what has happened. But the good part is that there is no imprisonment provision. Also, not so good from an individual perspective, but from organization perspective, not a penny out of this goes to the individual. Okay, no compensation provision. So probably there will be less dispute for money. Okay. Of course, it has its pitfalls, etc. I'm not getting into that right now, but that's what the penalty structure is. We can move to the next slide. So what happens now, right? This is a big question which is coming up. Draft rules have been rolled out, and till 18th of February, the consultations are on. I would again request, if you have inputs, please do provide. It would not be called out against a particular individual or entity's name. The government has said this will all be aggregated, anonymized, and probably finally the overall output from the consultation would be published, etc., but not against any individual or company's name. So in a way, that's good. After this consultation period is over, probably there could be a little bit of a additional time given, but don't rely too much on that. Consider 18th February to be the last date. After that, the government is supposed to assimilate all of this, and then the rules are to be brought into play. Now, when that happens, what will happen is, first, the data protection board related provisions will come into effect. And also, a timeline would be given for all the remaining compliances to be brought into effect by all the organizations. This could be in the region of 12 to 18 months, maximum to 24 months, depending on what they say. But you could consider about 18 months odd to prepare. But trust me, word of caution here, that we have seen the GDPR trajectory. 2 years were given to them who already had a law, but it was insufficient for them to ramp up to these capabilities. A lot to be done. I think we should start immediately. The government is also continuously saying this, that now there is nothing that you should be waiting for. The act has been there for quite some time. The rules have now been rolled out. Do not expect like dramatically a lot of changes will happen. So this is a good time that you start working towards compliance in relation to these actions. Okay, move to the next one. So if you see, a lot of things will change, but I think for every single organization, the most important thing is notice and consent. The level of granularity that has been talked about when we give notice is tremendous. Okay. In fact, cross-selling, upselling, etc., could see some friction, and therefore we have to be a little creative about how we are writing our notices and consent language. I will just pick up one thing from this particular slide, which is if you see the point number 3, where they've talked about in the rules that you have to have the notice should have itemized description of personal data sought to be processed, the specific purposes of processing such personal data, an itemized description of goods or services to be provided or uses to be enabled by such processing. So, in short, it ideally should say name, email ID, phone number for creating your account, things like those. So, now, there was this, as we attended some of these consultation meets, the question is coming out very prominently from several quarters that how granular, right? It might just become impossible to go very deep and kind of talk about everything on a practical basis. Okay. Of course, if you read the black letter of the right law, you have to write everything. But practically, we'll have to also see that there is some kind of ease of doing business and we are not stopping and stalling business. I think we can take a middle of the road approach. And we place ourselves in the shoes of a prudent user, right? Who should know, when we talk about certain usages, they should be able to fathom what is going to be the processing and what is for what purpose for goods and for what goods and services. I can give a simple example. In one of the previous consultation meets, there was one player from the telecom sector, and the question that the gentleman asked was, um, we provide data and we provide voice services. Now, are you expecting that for each of the line items,
मैं चला
data
गया
services, this is this,
ये
voice services, this
अरे
is. So
मैं
I think at that point in time, the minister had told
पेरेंट्स
that,
मीटिंग
listen,
कौन और ये
uh, take
तो
a judicious call,
पेरेंट्स
place yourself in the shoes of
ओबली
individual who's giving the consent. If the person is able to understand more or less that for telecom services, what all data would be required for what purposes, you can craft it accordingly. So here, I think a bit of creative crafting and crafting, which kind of makes the consent meaningful, will come into play. We can move. So over to you, Tanu. I think if you can talk about the impact.
I think just this is more in the context of advertising, let's say. And from all that Supratim has covered so far, there are fundamentally two buckets here. One is either you are a data fiduciary or you're a data processor, right? And most of the obligations are on data fiduciaries. And then the next, in terms of compliance, what becomes your, let's say, the first action item, so to say, is seeking consent, right, from people who own data or data principals, as the Act calls them. And then there are nuances of what that consent should comprise of. It needs to be detailed. It needs to be clear and precise. The purpose of why that data is being collected. What is it going to be used for? All of that needs to be specifically called out for you to have a valid consent, right? That's the fiber of what statutorily or the framework is aiming to set across. So now, what happens in the context of advertising, right? Some of the things that we, let's say, industry players today rely on, your reliance on that may sort of reduce. One, for example, it's a very common practice right now that towards the end, a user of a platform or a consumer would just have a checkbox. Do I consent to receiving marketing mailers? Do I consent to receiving promotional emails or messages or things like that? Now, all of that, because it is not so nuanced by the nature of it, you may not be able to fully rely on that. So that's one. The other is for a data fiduciary, and when you're taking that consent to use data, you would need to predetermine what you're going to use that data for. And your consent has to be nuanced to that extent, right? So a little bit of diligence, evaluation, and structuring in that context would be required. So you will have to, kind of revisit your processes around this consent seeking requirement. The other is just the volume or the pool of data related to consumers that you today can access or today is available to you because possibly because you run a platform, There are people who open their accounts and just by default, because they've opened their account, you have that data. Maybe there is data that you're, picking up from market. Now, all of that would shrink. So, because the consent needs to be nuanced, likely consumers would also eventually get more vigilant about what they're consenting to. So, just the general volume of data that is available to you for use may just simply shrink, and all of us perhaps will have to evaluate how is that going to affect the operational part of things, right? What is the reliance in terms of volume of consumers versus just consumers who have actively consented to something. The other fourth one, which I think would become like a massive exercise once all of this is in force, is your existing database will need to be audited. Because if you have consents, you may have consent from some users who may have said, okay, I agree to marketing mailers, or I agree that you can share it with third parties or so on, which is today, consumers are not very vigilant. The way consents are taken, it's almost like, they don't have a choice around it in most cases. People don't end up reading fine prints. So all of that data, which is not so explicit in terms of use, you'll have to audit it and, kind of put it into buckets, pick out content or pick out information that you can actually use versus you cannot use. And today, every organization is sitting with large volumes of data, especially I think the advertising sort of industry. So that audit will become not just a massive exercise, but also a very, very key, crucial tool eventually to ensure compliance. Right? That's the fourth. The next one would be again data that is procured from third parties, right? Now, because there is this nuanced consent requirement, your reliance on what you have obtained or procured from just a broker or just some entity that is selling data, you may have to reduce that uh, because the purpose for which you are using it may not be the purpose for which the consent is procured. You will not have that diligence or visibility on how that data has been collected by a third party. So just in normal course, reliance on that may reduce unless you do that back-end check in terms of the data that you are getting from a broker. What is the level of compliance that broker has implemented? All of that will become an exercise, and I feel that the general impact of that would be that people will slowly start relying less and less less and less on data banks. And the last I would say here is for every stakeholder, in the advertising segment. We'll have to ensure, because consent is a primary requirement, we'll have to make sure and do that verification that consent has been taken, who has it been taken from. You may be receiving data directly from consumers, you may be receiving it as an intermediary. If you're a platform that is simply facilitating, let's say, transactions of some kind, you are a middleman in that sense, but not actually somebody who's processing it. So what happens is it's a complicated sort of ecosystem in that sense. And what you need to do is, one, the diligence audit your own compliance of things, but wherever you are engaging a third party, whether for collecting data or for giving data, your best way is to have enough contractual protections as well. Right now, these are, India is still sort of evolving and getting there, but some of the other jurisdictions where, data laws are already in place, there are specific agreements to that extent. So all of that will come into play, but at the moment, for all of our vigilance, we should know that whatever contracts we are executing, where there is where there is a limb of exchange of data, those need to be reviewed properly, and you need to have back-end contractual protections around it, because the statute is very strict, as and when it comes into force. So if you don't have back-end contractual protections, you of course will have statutory remedies and so on. But your paperwork also needs to sort of support all of that. So that's what I would think from a consent perspective, are just action points that we should all sort of be mindful of. Sorry, I think I skipped this one. Yeah.
So I'll talk about the data breach notification now. And like I was mentioning at the beginning, I think data breach.
Just before you move there, I think I would just break that so far we've spoken about seeking consent. Right now we're moving to the next action item here, where there is a breach and then what somebody needs to do. Right, so that's what we're going to cover in the next couple of slides.
Right. So I think data breach notification is one aspect which all of us should be mindful, because this is a problem of today as well. Okay. Of course, going forward, it will become even more rigorous, etc. Why I'm talking about it this way is because if you look at CERT-IN, Computer Emergency Response Team of India, it says that you have to report the cyber incidents within 6 hours of either observing the breach or being brought to notice about it. And there are players who are getting show cause notices because they have not reported this within 6 hours. Now, this is about cyber incidents. Okay. The DPDP Act is going to talk about digital personal data breaches. Now, in most of the cases, you will see both will be triggered. It will be a cyber incident which will contain personal information, or personal data breach has occurred because of a cyber incident. So you have to go to both the regulators. Now, what does this draft rule say? It says that you have to do three things. One, you have to immediately go to the data protection board and give certain information. Within 72 hours, again go to them and give much more information. And all of this is there on your slide in front of you. And you have to also go to the individuals and tell them, impacted users, and tell them that what has happened, what is the consequence of what has happened, what they can do to mitigate, what you have been doing to mitigate the issue, contact details of whom they can reach out to, etc. Now, the problem is that in 72 hours, probably you will understand nothing. And the expectation is that you have gone within 72 hours to the board 2 times. Also, you have informed the individuals by that time. Okay. So, what we are requesting, at least to the ministry, is that there should be a more kind of risk based approach to this. Not everything needs to go through this kind of process. Not every kind of incident or breach that they have drafted as a definition of personal data breach. That's like anything under the sun, by the way. So, let's see which way it moves. But why this is critical is, in a bad day, your energies should be channelized to contain the breach, etc. Not really running behind 3-4 regulators. And if you and we have done this reporting to individual, if you write to 5 lakh people, at least 1,000 of them will come back asking further questions, and your energies will get channelized to that. So something maybe you can ponder over and give some comments if you want. We can move to the next slide. Yeah, I think, Tan, if you want to take this.
Yeah. So I think the larger point here is, on this slide, and this is again in the context of sort of the advertising industry, right? Now, unlike some of the other industries, this distinction between whether you're a data fiduciary or a data processor becomes sort of blurred in the advertising context, because most stakeholders are, perhaps doing multiple or fulfilling multiple functions in terms of just their business operations. And the obligation from statutorily is more on the data fiduciaries, like we said. You can, at the back end, in your, like I said, as a fiduciary or somebody who's procuring or engaging a third party for processing data, you could have some contractual protections to sort of relay that compliance or pass on that onus to the data processors also. But what will happen, because your operations are sort of blurry and multiple organizations are doing multiple things, it'll be difficult for you to bucket yourself simply as a data fiduciary or simply as a data processor, right? So that evaluation will have to be done. That's one. And when you evaluate it, the evaluation will have to be, okay, what data am I directly procuring? What data am I passing on? How much of that data is being processed for my own operations? How much of that data I'm simply giving away to somebody, let's say a service provider who's simply doing what I'm asking that entity or organization or an individual to do, right? So that distinction between whether you fall on the side of data fiduciaries and therefore are obligated for everything, or you are simply a data processor and then can argue that, okay, I can get away with this because this is an obligation of data fiduciaries and I'm not a data fiduciary. That will have to be evaluated basis your business operations, basis the data that you're collecting, how you're processing, how much of it are you sharing, and that sort of evaluation becomes necessary. And why I'm explaining this is because the obligation to report a data breach is there with timelines across regulators, all of that, right? So, and if you don't report it, then the non-compliance is on your head. So just from that lens, that evaluation sort of will need to be done. One of the things that data fiduciaries can do, if you're falling in that bucket, is to ask your data processors also, if the breach is at their end, then they will have to notify you. So that you can comply with the reporting obligation. So that sort of cross linkage in terms of functions, compliance, reporting obligations is something that the fiduciary is responsible for, and the fiduciary then needs to ensure that the entire ecosystem across stakeholders, across entities they have engaged, and their own infrastructure is ready for it, and is supporting compliance. Larger point being, the obligation to report a data breach is strict. The timelines are strict, and the first step to that would be to identify whether you are a data fiduciary or not in the first place, right? And that, I feel, in the advertising context is a little bit blurry. So every organization will have to sort of do that evaluation and internal assessment, that are we purely processing data? And I can, maybe as a rough example here, could be, let's say we run a campaign across different mediums for advertising a certain product or a service, or whatever it is, and we engage one organization where we are outsourcing bulk messaging or bulk emailing. Now that entity, to facilitate that bulk emailing or facilitate that bulk messaging, you will have to pass on consumer data that is available with you in terms of, okay, there are 100 people who need to be sent these mailers. But what that entity is doing is simply acting and simply pushing out emails, right? So in terms of that particular function, they are perhaps only data processors, and the organization that has passed on that data or is running the campaign is the data fiduciary, right? But at the same time, this is an example which is very contextual to this particular engagement. But a lot of data processors or entities who are, let's say, just facilitating or fulfilling this function in this context could be doing other things. They could perhaps be advertisers themselves. They could perhaps have a platform themselves where they're running some sort of, they could perhaps be tech supporters as well. And by virtue of those other functions, they will have access to data which they have directly procured. And to that extent, then they are data fiduciaries also, right? So this is just a broad, rough example, but the point being that in the advertising context, the lines are a little bit blurry. So that defense that I am only processing data may not be available to you all the time, although it may be available to you for specific functions.
Right. I think we can move on to
Yeah.
the next slide. And this is a very important one, reasonable security safeguards. Okay. The industry is, again, trying to give feedback on this one. Firstly, there is no hard standard which has been called out, like, under the Information Technology Act and the Reasonable Security Practices rules. It says, which is called the SPDI rules. You will see ISO 27001 was called out as a specific standard. In this one, they have not done that, but they have given some baseline requirements for reasonable security safeguards. Issue with this is that there is again no risk-based or harm-based principle which has been brought out. It's like all kind of personal data should have this kind of say security safeguard. The industry is saying that that may not be an absolutely good approach to take. You should protect, of course, more sensitive kind of data more dearly and with more rigor, rather than everything under the sun. So what have they talked about? They of course talked about technical measures which can be taken, like encryption, obfuscation, etc. Implementation of appropriate access control mechanisms, monitoring and logging requirements to prevent unauthorized access, and maintaining of confidentiality, continuity in measures to ensure that availability and integrity of personal data, and retention of logs in case there is a breach for a period of 1 year. Now, interestingly, this log retention is going beyond what the present day law is saying. When the cert in talked about that 6 hour, sorry, I think so. When the cert in came out with their 6 hour breach reporting requirement, what they also said is that you should keep 180 days rolling log of all your ICT systems within the country. This provision is taking this beyond that 180 days, and saying that in case there has been any incident, then you have to keep that log, including personal information that is involved in that, for a period of 1 year. Okay. So important to take note of. We can move to the next slide. Yeah, maybe quickly if you want to cover the impacts.
I'll just quickly cover this. So again, this is now the third leg of what a compliance action is, to set up security safeguards. So, largely the same concept, depending on whether you identify yourself as a data fiduciary or a data processor. This compliance obligation sort of falls on you as well. Right now, to the extent you are a data fiduciary, because this obligation is on data fiduciaries, you will need to set up all of these safeguards. What is also important is that when you're engaging a third party and you're passing on data to that third party because you've outsourced a certain function or a certain process to another third party, you will have to ensure that that third party also has set up these safeguards, right? Even though the statute says that data fiduciaries are supposed to do that. But the only way that you will safeguard data, and the underlying principle of all of this, is that data is safeguarded. And there are no breaches, there are no leakages, there is no unauthorized use, and so on. So one is that you will have to set up your own process and safeguards around it. The other is to ensure that the third parties that you rely on for your business operations where data is being shared, how do you ensure that they have at least similar processes and security standards as you have adopted, right? Because the data needs to be dealt with the same level of diligence. One of the ways you can do it, obviously, is contractually, that your contracts are watertight. If you have specific, let's say in your organization, you've taken a call, because today there are no minimum standards of these measures that are prescribed. But as an organization, if you've taken a call that we've done these 4 things, right, whether that's a software or entry point barriers or whatever it is, if we have taken these 4 measures, how will you be able to pass that on to another entity? The most helpful tool there at least today becomes your contracts, right? So that level of diligence with all third-party contracts needs to be done. And then, of course, there are legal remedies in terms of the data processor representing you, taking on obligations, indemnities, and other legal recourses. But the larger point being, without getting into the nitty-gritty of what contracts should say, the larger point being that you will need to review, and it's a must to review your contracts with third parties wherever data is shared. And then, yes, minimum standards I spoke about. The last point here being that one is that you've set up a system, you've looked at your contracts and you've made them watertight. So that is done. But post that, unless you periodically keep reviewing and assessing that your systems are working, are the security standards working, are the third parties that you're engaging complying with all that the contracts are saying, all of that needs to have some internal security scrutiny audit around that. So there needs to be some periodic revisiting that needs to be done with the processes going forward. And needless to say, all of this is going to cost something, both in terms of resources, infrastructure, consulting advice, and so on. So, some amount of budgeting going forward will need to be done just to set up all of this compliance also and to protect yourself preemptively.
Right. I think moving on to the next important piece, which is significant data fiduciary. Now, very simply put, what is this significant data fiduciary? So our law categorizes data controllers as two types. Okay, one is the normal data fiduciary, which is every other player, and significant data fiduciary are players who are crunching huge volumes of data, more sensitive personal data. There is more risk to individuals which could be caused. There is a potential impact on the sovereignty integrity of the country, public order, security of state, etc., etc. Now, what will be these players? What specifically would be these players? Would be called out through separate notifications, but they will have to have they will be having additional compliance requirements. For example, they will have to have a data protection officer. Yeah, they'll have to do certain filings and carry out data protection impact assessment, audits, etc. The rules, interestingly, the draft rules add some more color to what additionally they have to do. And one interesting element which has come in is that these kind of players will have to do algorithmic due diligence. Like, you can consider this to be one of those first elements in a national legislation in the context of AI. Okay. And what does it say? It says that SDFs must undertake due diligence to ensure that algorithmic software used by them for handling personal data is designed and verified to safeguard against any risk to the rights of data principles. So, in effect, meaning that you have to ensure that all the rights that have been talked about under this law are kind of not vitiated in because you've used certain kind of algorithms or algorithmic software within the institution. There is a requirement to do data protection impact assessment on a yearly basis and also audits. There is some confusion around that. DPIAs, many players think, should be for only high risk processes, not like the entire institution or organization. Also, one technical issue which is coming out here is that till date, the government, the ministry has been constantly mentioning that the body which will oversee this particular law would be Data Protection Board of India. It is supposed to be largely an adjudicatory body. Now, suddenly in the draft rules, it says that this particular DPIA, data protection impact assessment and audit, that is carried out on a yearly basis by the significant data fiduciaries, summary or the relevant important aspects of these need to be given as a reporting to the Data Protection Board of India. Now, this is almost coming out of nowhere because that body was never supposed to handle any kind of filings. It's just an adjudicatory body largely, right? So again, submissions are being made on this, and if you feel that you are also pained by this, do definitely try to put in this as a submission. We can
So
move to the yeah.
just one point here would be that for significant data fiduciaries, if one of the criteria, and it's almost like the primary criteria, right, for you to be bucketed as a data fiduciary versus a significant data fiduciary is volume of data that you have and that you are using or processing, right? Now, just in the advertising context, my sense is that most organizations are going to fall in this bucket, right? Whether you're an agency or a publisher or an ad tech platform, in whichever ecosystem you are, or whichever role you're sort of playing, you are most likely going to be falling in this bucket or being, will be categorized as a significant data fiduciary because, uh, this sort of industry functions on data, right? So this is something to be very vigilant of. And, like Supratim is saying, the consultation is still on. And I think it's very important for the stakeholders here as well to look at all of this and then assess what is practically doable, what is not practically doable, and give those comments and thoughts in time before the legislation is out and it's a little too late by then to sort of amend anything. But just highlighting that most stakeholders in the advertising space, especially those who have been around for a long time, are likely to fall in this category.
Okay, I think we can move to the next slide, and we'll now go, I think, a little quicker to see that
Yeah.
we're able to take enough questions also. There are certain players, certain kind of players, like Tanu was mentioning, the basis has been that, how many registered user they have, etc. So uh, e-commerce platforms with more than 2 crore users, social media intermediaries with more than 2 crore users, and online gaming intermediaries with more than 50 lakh users, they have been told that there is a limitation period of retaining personal data, which is about 3 years, and the threshold parameters are provided there. The question which is being raised in this context is, why only these players? What was the basis of choosing these 3 players only, etc.? Uh, but okay, so again, if you're impacted by this, definitely, I'm sure that you'll be putting in some submissions on this. We can move to the next slide. International data transfers. I think this is which we should be extremely mindful of. Many of you would be having cross-border data transfers. So I already told you what was envisaged in the DPDP Act, the mother legislation, which is like free transferability of data across jurisdictions. No problem. Only two catches. One is the government will come out with a short negative list of jurisdiction transacting in data QA, those jurisdictions could be restricted. And the second one is, if there is a stricter law, then that will prevail over this general leeway. Additionally, interestingly, what has happened through these rules is that some frills have been brought in, which again, a lot of industry players are planning or already giving inputs around. Apparently, 6,000 submissions have already happened, and the last date is 18th February. So you can imagine how proactive people are right now on this. So on this, what are the two additional things which has happened through the rules? One is that in case the data is going to a jurisdiction where the government or the government agency there in that foreign jurisdiction can look into that information, there could be certain restrictions which could be brought in. Okay, that's one. The other one is in the context of significant data fiduciaries, which we just discussed are certain kind of higher threshold players. Regarding them, there could be restrictions regarding transfer of certain kind of personal information. Now, if you look at it, this is in a way a bit divergent from what has already been told in the mother legislation, the DPDP Act. Therefore, there are submissions which are getting planned in this context. Let's see where this goes. But maybe very important to take note of if you are having cross-border data transfers. Okay, we can move to the next slide. Yeah. Oh, okay. Children's personal data. Important aspect, firstly, is age of child is fairly high in our country, which is 18 years. Under, say, EU, GDPR, it is 16 years. It can go below up to 13 years, depending on the member state. And what are the embargoed items? Embargoed items are firstly, you will have to do a verifiable parental consent has to be carried out when you're handling children's personal data. Some nuances of as to how this can be done has been brought into through the draft rules. Second point which has been mentioned is that nothing should be done which is detrimental to the well-being of the child. And the third thing which has been talked about is no targeted advertisement and no uh, tracking or monitoring of children. Okay, now there are a lot of counter arguments also. Let me play out some of those. One is that every platform would have trust and safety tools which just tries to check whether it's a child, whether it's someone else moving around on the platform, and that's actually a safety feature. Point number two is if you don't have targeted advertisement, you could have a situation where the child observes every advertisement, right? So things like those. So again, there are claims, counterclaims, and all of that is getting paid out. If this is of relevance, which I think would be of relevance for most of you here, you should try and put in your submissions in relation to the draft rules. We can move to the next slide. Yeah, maybe Tanu, you want to come in on the impacts here?
Yeah, I think the point is simply similar. That evaluation of whether you're a data fiduciary or not, it becomes relevant. And then in the digital space where you're let's say you operate a website or a certain kind of platform, if you're collecting that data directly, then all of these sort of controls, uh, parental consent, maybe there are tech measures around parental control, etc. All of that then needs to be evaluated and put in place. But again, like Supratim says, the obligation is that, which function are you playing? Which piece of the, sort of the entire ecosystem are you? Is that control being done at a certain level and therefore you don't need to do it? So all of that needs to be sort of reviewed and evaluated. The impact is, of course, more around, guardian and parental consent. So, quick one here.
Yeah, sorry, I think I also forgot to mention that apart from the child-related provision, there's also one for guardians, which where you have to do diligence and check whether it's actually a guardian or not. For the child-related verification, thankfully, of course, some tools are getting developed, I understand, from the government end, which will make it more secure and less data guzzling as far as verifiable parental consent is concerned. But yeah, so we can move to the next slide now. Yeah, this is consent manager. I think there's some questions also in relation to consent
Yeah.
manager. One of the first and most important thing is a bit of demystification. Okay, you need not mandatorily become a consent manager. Somehow, I think your own consent management system versus what consent manager has been talked about in this law are two different things. You have every right to do your own consent management system. You know how consent should be managed within the organization, within the conglomerate. There is no problem there. This consent manager that has been talked about is almost like a third party service provider of sorts for individuals. Okay, I'm again crudely speaking, and let me give you the background where this thought process came in relation to consent managers. When we traveled with Justice Sri Krishna across the country, we realized that consent is actually a very weak ground of processing personal data. The reason is large illiterate population, people are speaking varied languages. Even the most educated people are actually not reading anything that is written there when we give our consent, right? We just simply press, I agree, I accept, and move ahead. So, very crudely speaking, what if we had a service provider of sorts in between, right? Where I can almost, again, crudely speaking, give a power of attorney to this service provider and say, listen, wherever I'm going, I'm okay to give my consent for A, B, C, but I'm not okay to give my consent for X, Y, Z. And that's taken care of. So again, very, very rough understanding of this particular player. Now, this player, therefore, is a fiduciary for the individual. It cannot have a conflict of interest as far as the data fiduciary is concerned, okay? Because then they might not be taking care of my wishes properly. Some requests are being made in relation to that relaxation of provisions for conflict of interest, etc. But broadly, what you see in front of you is what has been given in the Act and the rules. Functions of the consent manager is to enable data principal to provide consent for processing personal data, facilitate direct indirect consent, ensure interoperability, maintain data blindness. Okay, they have to maintain record. There are transparency requirements. There are operational and financial conditions. For example, 2 crore of net worth, minimum net worth. There are fiduciary duties, so quite a bit. Okay, um, and the question therefore is, why should someone do it? What is the business case? Why would will someone do it for charity, or individuals will have to pay for hiring a consent manager? That question is still open. What we hear from the ministry of late is that, okay, they don't want to go down the route of individuals paying for the consent managers. If that be the case, then has to be another viable option given to such players. Just as an example, it could be usage of the uh, data that they are handling on an aggregated anonymized basis, of course, for on a sector specific basis. Then it makes a lot of sense for them, okay, that I can utilize that aggregated anonymized data output to do something, right? So let's see where this is headed. But again, please don't break your head over this, that I should stop preparing my own consent management system in my organization. We can move on. Okay. Rights of data principles, I think we have talked enough about, and this is largely an extension from the act. We can move. We're trying to save some time for Q&A. This, I think I can write to nominate, right of erasure. This has been there on the act. I think we can move on this one. Yeah.
Yeah, I think we'll cover all that in the questions.
Yes.
The number of questions we just moved on. Yeah.
So we can move
on.
Yeah. I think this is all fairly simple and nothing, this is again, you can understand, like any other jurisdiction, the government can call for information regarding in the interest of sovereignty integrity of the country. This can create some problems for certain jurisdictions. For example, EU, you would have done transfer impact assessments when you're sending data from EU to India, and one of the things that they check is that does your country have surveillance laws? Does your government, can they look into the data? If yes, do you have any safety mechanisms, security mechanism as to how this data is taken, why it is taken, and do we have a remedy against such request, etc., etc. So this could be actually it could become important in that context. Okay, so I think we can move on, and that's about it.
I think this is just we'll just
Summary.
wrap up what we've spoken about, just slightly more in the context of advertising. We started, of course, with the notice requirement to data principals. Or data principals are people who own data or the personal data relates to. So there is notice and consent requirement. And the infrastructure around that, the paperwork, compliance, policies, all of that needs to be evaluated and set in place. Then we spoke about security measures and practices. So, it's important for you to set up your own security measures and practices basis, a call in terms of, what is the threshold or what is the standard that you're going to follow for your own organization. But also, if you're engaging third parties for simply processing also, you will have to do some diligence and relay those obligations to them as well. The third was breach reporting. Now, this is again similar. One is your own infrastructure to set up to identify a data breach and then follow the compliance through. But also, if you share data with a third party, then what is the setup there? How quickly are you going to be notified of a data breach at the end of a third party? Because the timelines are still the same. That argument that the data breach did not happen at my end but happened at somebody else's end may not sort of work in every scenario. Significant data fiduciaries, there is higher compliance obligations on significant data fiduciaries. And like we spoke, most major stakeholders in the advertising space, I feel, are going to be categorized in this basis, just the volume of data that the industry sort of deals with.
Think anything else, or should we
Yeah,
jump
and
on to the
then
questions?
I think just minor, just to wrap up, I think a few other points here. We may have to, what we spoke about right now are just actions which are in the statute, in the rules, and they will develop. So there are more legal compliances. But at the back of that, there is also, you will perhaps need to develop and adopt stronger or newer, more innovative technology just to sort of take care of all of this. And in the advertising context, I think tech becomes even more important because a lot of personalization sort of also happens basis that data. So you'll have to have tools and methods which are kind of balancing between compliance, privacy, but also don't take away the benefits of personalization at both ends, at the organizational end and at the consumer end as well.
Yeah, I think very valid point made. I think the way to look at it is people, process, technology. All three you have to kind of balance here.
Yeah.
And just to give a rough roadmap, maybe how we can go about doing this. Usually we break this into three parts. Okay, when we are assisting our clients. First part is of course training, sensitization, and workshop. Maybe the leadership will require a 45 minutes to 1 hour of general context setting and what program we will run, and for the privacy champions, as we call it, like people who are from the marketing team, IT, legal, everywhere. Like it's not one person's job. So these set of people that we pick up from different business functions of an organization, we have a very intense workshop for them in which they also go through simulation exercises, very pointed questions pertaining to their work area, etc. So that's the first phase, right? The second phase is the gap analysis, and you'll see all of this, uh, here in our slide. So, which is where we are today and where we have to reach, which is the gap analysis phase. And the third one is plugging of those gaps. Okay, now, like Tan was mentioning, it could be technology, it could be a process elevation, it could be documentation, which you need to better now through your contracts, notice, consent, etc.
Yeah, so notice we spoke about, so I'm going to skip that. And training, Supratim spoke about. There are, of course, nuanced trainings that we do. But the larger point being that everyone in the organization, right, it's difficult, especially I think in the advertising space, because everyone is perhaps involved in the chain, in the output at some level. So just that sensitization across levels organizationally is sort of important, right? Because one can say that, okay, I have a compliance team and compliance team will take care of it. But that may not be sufficient because your operations are dependent on that data. The compliance team needs to understand what is happening at ground level. The ground level needs to understand what is the obligation of what is the compliance team doing, what are they required to do. So that just basic awareness, sensitization is sort of, I think it's very, very key going forward and, starting from now. And just last point being that some of the things that could be thought about, and this is a call that every organization can take. This is not statutory, of course, but to be able to implement all of this, right? There needs to be some thought around what are our audit mechanisms? How quickly, how soon, at what intervals are we going to review our compliance, right? What is the risk to that organization in terms of penalties, but also in terms of, there is one data breach and there could be repercussions in terms of you having access to even lesser data going forward because there is a reported breach and so on. So risk assessment, if there is a breach of some sort, if you have fallen into that space where the risk is now, it is the reality. Today it's still theory, but at some point it will become reality. What is your mitigation plan around it? Who are the people in the organization who are going to deal with it? Who are the people who are trained and equipped to deal with it? What are your systems? What are your security measures? So, some thought around that. And I feel the best way could be to have, at least smaller committees in every organization who has, a broader picture of what is simply compliance, what is operational, and what needs to be done today and going forward. So these are just some measures that organizations can think of.